Florida just became ground zero for the most aggressive deportation enforcement in America. If you rent property, employ workers, or live as an undocumented immigrant in Florida, what happened in 2023 and 2024 has set the stage for 2026 to be absolutely brutal. We're talking about laws that force landlords to verify immigration status, employers facing felony charges, and entire families ripped apart because of a traffic stop. This isn't fear-mongering. This is Florida law right now. And if you don't know what's coming, you could lose everything. Stay with me, because what I'm about to reveal will shock you. Number 1. SB 11718 turned Florida into an immigration enforcement machine. In May 2023, Governor Ron DeSantis signed Senate Bill 1718 into law, and it fundamentally changed how Florida handles immigration enforcement. This wasn't just another political statement. This law created real criminal penalties and civil requirements that affect everyday people. The bill went into effect July 1st, 2023, and it touches housing, employment, transportation, healthcare, and even churches. Florida became the first state to require hospitals receiving Medicaid to ask patients about their immigration status on intake forms. That data gets reported quarterly to the state. But the housing provisions are where things get terrifying for both tenants and landlords. If you're renting in Florida right now, you need to understand that your landlord may be legally obligated to verify your immigration status, depending on how the property is classified. And if you're a landlord who ignores these rules, you're looking at third-degree felony charges. The law also increased penalties for human smuggling and created new criminal offenses related to transporting undocumented individuals across state lines into Florida. What makes SB 11718 particularly aggressive is that it doesn't just target undocumented immigrants themselves. It goes after anyone who helps them, houses them, employs them, or transports them. This creates a web of legal liability that extends to family members, employers, landlords, and even charitable organizations. The ripple effects are massive, and we're only now beginning to see how this law reshapes daily life in Florida. Number 2, landlords must now verify tenant immigration status in certain cases. Under SB 11718, any person or business that knowingly harbors undocumented immigrants can face felony charges. This includes landlords. While the law doesn't require every landlord in Florida to run immigration checks on all tenants, it creates a legal environment where landlords are now hyper-cautious. If a landlord knowingly rents to someone without legal status, and that person is later discovered by law enforcement, the landlord could be charged with a third-degree felony. That means up to 5 years in prison and a $5,000 fine. This has led to widespread fear among immigrant communities and confusion among landlords. Many property owners are now requiring additional documentation during the application process, including social security numbers, work visas, or proof of citizenship. Some are even using E-Verify, a federal system normally used for employment verification. If you can't provide these documents, you may be denied housing even if you have the money to pay rent. This is happening right now across Central and South Florida. Real estate attorneys are advising landlords to implement stricter screening procedures to protect themselves from potential criminal liability. The problem is that this creates a discriminatory environment where people with accents, Hispanic surnames, or certain ethnic backgrounds are being subjected to additional scrutiny that white applicants never face. Fair housing advocates argue this violates federal law, but landlords counter that they're simply trying to avoid felony charges under state law. The legal tension between federal fair housing protections and Florida's aggressive immigration enforcement creates a minefield that neither landlords nor tenants can safely navigate without legal counsel. Number 3, E-Verify is now mandatory for many Florida employers. SB 11718 didn't just target housing, it also went after employment. Any private employer in Florida with 25 or more employees must now use E-Verify to confirm the work authorization of every new hire. This requirement kicked in July 1st, 2023. E-Verify is a federal online system that checks a worker's information against Department of Homeland Security and Social Security Administration records. If you're hired and your information doesn't match, you're flagged. And if an employer knowingly hires someone flagged as unauthorized, they face severe penalties. For a first violation, the employer's business license can be suspended for up to 1 year. For a second violation, the license is permanently revoked. This has created a chilling effect in industries that rely heavily on immigrant labor, including agriculture, hospitality, and construction. Workers are being let go, families are losing income, and employers are terrified of making a mistake. The Florida Department of Economic Opportunity is responsible for enforcing these requirements, and they've already issued warnings to hundreds of businesses. Some employers are now requiring all applicants to provide documentation before even scheduling an interview. Others have stopped hiring altogether for certain positions because they can't find workers who pass E-Verify screening. The agricultural sector has been hit particularly hard. Florida produces nearly half of America's citrus and significant portions of tomatoes, strawberries, and other crops. These industries have historically relied on immigrant labor, both documented and undocumented. With the E-Verify enforcement, growers are reporting severe labor shortages. Crops are rotting in fields, prices are increasing, and some farms are considering relocating operations to other states with less aggressive enforcement. Number 4, transporting undocumented immigrants is now a felony. Here's where Florida law gets really extreme. SB 1718 made it a third-degree felony to knowingly transport an undocumented immigrant into Florida. That means if you drive someone across state lines into Florida and that person doesn't have legal status, you could be arrested and charged with a felony. This applies even if the person is a family member. It doesn't matter if you're helping your cousin move from Georgia to Tampa or picking up a friend from the Alabama border. If they're undocumented and you knowingly brought them into Florida, you're breaking the law. The penalty is up to 5 years in prison. This provision has caused panic in immigrant communities. Families are afraid to travel. People are avoiding medical appointments out of state, and the enforcement of this law has already begun. Florida law enforcement agencies have been trained to identify and investigate potential violations during routine traffic stops. When officers pull over a vehicle near the state border and find multiple passengers who cannot provide identification or proof of legal status, they're now asking questions about who drove the vehicle into Florida and whether the driver knew about the passenger's immigration status. These traffic stops can lead to criminal charges against the driver, even if that person is a U.S. citizen. Defense attorneys have challenged this provision as unconstitutionally vague because it requires proof that someone knowingly transported an undocumented person. How does a driver know for certain whether their passenger has legal status? The law doesn't provide clear guidance, but prosecutors argue that willful blindness counts as knowledge. Meaning, if you had reason to suspect someone's status and didn't ask questions, you can still be charged. This creates an impossible situation where giving a ride to a friend or family member could result in felony prosecution. Number 5, Florida invalidated out-of-state driver's licenses from certain states. Another provision of SB 1718 that blindsided many people involves driver's licenses. Florida no longer recognizes driver's licenses issued to undocumented immigrants by certain states. Specifically, licenses from Connecticut, Delaware, Hawaii, Rhode Island, and Vermont are now invalid in Florida if they were issued to someone without proof of legal presence. This means if you're driving in Florida with one of these licenses, you're driving without a valid license under Florida law. You can be pulled over, cited, arrested, and even have your car impounded. This has created a nightmare scenario for people who move to Florida from these states or who are visiting family. They thought they were following the law by getting a state-issued license, but Florida decided those licenses don't count. And once you're pulled over, you're now in the system. Immigration and Customs Enforcement can be notified. Deportation proceedings can begin. The states affected by this provision have filed formal complaints arguing that Florida is violating the full faith and credit clause of the U.S. Constitution, which requires states to respect the official acts and records of other states. But Florida lawmakers argue they have the right to set their own standards for which licenses are valid within state borders. The practical effect is that thousands of people who were legally driving in their home states are now criminals if they drive in Florida. This affects not just immigrants, but also people visiting Florida for tourism or business. Car rental companies are confused about whether they can rent to someone with a license from these states. Insurance companies are denying claims when accidents involve drivers with these licenses. And law enforcement is conducting targeted enforcement along highways leading into Florida from neighboring states. Number 6, local law enforcement is required to cooperate with ICE. Florida Statute 908.101, which has been on the books, but was strengthened in recent years, requires all state and local law enforcement agencies to cooperate with federal immigration authorities. This means if ICE requests assistance, Florida police, sheriff's offices, and jail facilities must comply. They must honor immigration detainers, which are requests from ICE to hold someone in custody for up to 48 hours after they would otherwise be released, so ICE can pick them up. Florida also prohibits sanctuary city policies. Under Section 908.0105, any local government that adopts a policy restricting cooperation with federal immigration enforcement can lose state funding. Elected officials who implement such policies can be removed from office. This has created a statewide network where every arrest, every traffic stop, every interaction with law enforcement can become a pathway to deportation. And it's not just undocumented immigrants who are at risk. Legal residents with certain criminal convictions can also be flagged and referred to ICE. The cooperation requirement extends beyond just honoring detainers. Florida law enforcement agencies are now sharing arrest records, booking photos, and biometric data with federal immigration databases. When you're arrested in Florida for any reason, your fingerprints are automatically checked against immigration databases. If there's a match indicating you have an immigration violation or prior deportation, ICE is notified immediately. Some Florida counties have gone even further by allowing ICE agents to have offices inside county jails. This means ICE can interview inmates, initiate deportation proceedings, and coordinate transfers without ever leaving the facility. Immigration attorneys have extremely limited access to their clients under these arrangements, making it harder to provide effective representation. Number 7. Florida courts are cracking down on false documents. Using a fake social security number, fraudulent work visa, or forged immigration documents is a serious crime in Florida. Under Florida Statute 817.568, it's illegal to use false identification to obtain employment, housing, credit, or public benefits. If you're convicted, you face a third-degree felony charge, which carries up to 5 years in prison and a $5,000 fine. But here's the kicker. Florida prosecutors are now working closely with federal immigration authorities. If you're arrested for using false documents, you're not just facing state charges, you're also being flagged for federal immigration violations. This can result in immediate detention by ICE and fast-track deportation. And it doesn't matter if you've lived in Florida for 10 years, own a home, or have U.S. citizen children. The use of false documents is a deportable offense. Florida courts are not showing leniency. Plea deals are rare, and once you're in federal custody, your chances of staying in the country dropped significantly. The crackdown on false documents has created a crisis for people who used fake social security numbers years ago to get jobs and have been working and paying taxes ever since. Many undocumented immigrants use individual taxpayer identification numbers, ITINs, to file taxes. But employers often require social security numbers for payroll systems. Workers who provided invalid numbers a decade ago are now being arrested and prosecuted when employers audit their records or when government agencies cross-reference databases. The Florida Department of Revenue has been sharing tax filing information with immigration enforcement agencies, which has led to workplace raids and mass arrests. Entire families have been thrown into chaos when the primary breadwinner is suddenly arrested at work and placed in deportation proceedings. Defense attorneys argue that prosecuting someone for using false documents years ago, especially when they've been paying taxes and contributing to society, is unjust. But Florida prosecutors maintain that document fraud undermines the integrity of government systems and must be punished. Number 8. Tenant rights are unclear when landlords demand immigration documents. Florida's landlord-tenant law is governed by Chapter 83 of the Florida Statutes. Traditionally, landlords could ask for income verification, credit checks, and references, but immigration status was not a standard screening criteria. That's changing. Because of SB 11718 and the threat of felony charges, landlords are now asking tenants to prove legal status before signing leases. But here's the problem. Florida law doesn't clearly define what documents a landlord can legally demand or how that information can be used. Some landlords are asking for passports, green cards, or work visas. Others are requiring social security numbers and running them through verification systems. Tenants who refuse to provide these documents are being denied housing. But if a landlord uses this information to discriminate based on national origin, that's a violation of the Fair Housing Act. The legal gray area is massive. Tenants don't know their rights. Landlords don't know their liabilities. And immigration attorneys are overwhelmed with cases. The U.S. Department of Housing and Urban Development, HUD, has issued guidance stating that landlords cannot discriminate based on national origin or citizenship status when that discrimination has a disparate impact on protected classes. But Florida landlords argue that they're not discriminating based on national origin. They're simply verifying legal status to avoid criminal liability under state law. This conflict between federal fair housing law and state immigration enforcement creates confusion and fear on both sides. Tenants are afraid to assert their rights because doing so might trigger an investigation into their immigration status. Landlords are afraid to rent to anyone who seems potentially undocumented because of the threat of felony charges. The result is a housing market where discrimination is rampant but difficult to prove or challenge legally. Number 9. Deportation can happen even if you're a legal resident. A lot of people assume that if you're a lawful permanent resident, green card holder, you're safe from deportation. That's not true. Under federal immigration law, legal residents can be deported if they commit certain crimes. These are called aggravated felonies and crimes involving moral turpitude. Florida has one of the broadest definitions of criminal conduct in the country, which means actions that might be misdemeanors elsewhere can be felonies here. For example, drug possession, theft over $300, domestic battery, and DUI with injury can all trigger deportation proceedings. And because Florida law enforcement is required to cooperate with ICE, a simple arrest can lead to an immigration hold. Once ICE is involved, even if the criminal charges are dropped, you can still be placed in removal proceedings. Florida immigration courts are backlogged, but they're also among the toughest in the nation. Judges here have some of the lowest asylum grant rates and highest deportation rates in the country. If you're a legal resident with any criminal history, you need to consult an immigration attorney immediately. The definition of aggravated felony under immigration law is much broader than what most people think. It includes offenses like shoplifting if the sentence imposed is 1 year or more, even if the sentence is suspended. It includes simple battery if it's classified as a crime of violence. And it includes drug offenses that many states have decriminalized, like possession of small amounts of marijuana. Florida has not decriminalized marijuana possession, and even a misdemeanor conviction can trigger deportation for a green card holder. What's particularly cruel is that many legal residents have lived in the United States for decades, have U.S. citizen children, own businesses, and pay taxes. But a single criminal conviction can result in mandatory detention and deportation with no possibility of relief. Number 10. What this means for families, workers, and communities. The cumulative effect of these laws is devastating. Families are being separated. Workers are losing jobs. Tenants are being evicted or denied housing. And the fear is pervasive. Mixed status families, where some members are citizens and others are undocumented, are facing impossible choices. Do you risk driving your child to school? Do you take your spouse to the hospital? Do you report a crime? The answer is increasingly no, because any interaction with authorities can lead to deportation. Small businesses are struggling to find workers. Construction projects are delayed. Agricultural operations are shutting down, and rental markets in immigrant-heavy areas are seeing vacancies because people are fleeing Florida. Churches and nonprofits that have traditionally provided shelter and assistance to immigrants are now worried they could be charged with harboring under SB 11718. The social fabric of communities is being torn apart, and this is only the beginning. As we move into 2026, enforcement is expected to intensify. Federal immigration policy under the current administration is prioritizing deportations, and Florida is fully aligned with that agenda. The economic impact alone is staggering. Studies estimate that undocumented immigrants in Florida contribute billions of dollars annually in taxes and consumer spending. They work in industries essential to Florida's economy, including tourism, agriculture, construction, and healthcare. When these workers leave or are deported, businesses lose revenue, tax collections decline, and entire sectors face labor shortages. But the human cost is even greater. Children are growing up without parents. Elderly family members are left without caregivers. Communities are losing neighbors, friends, and contributors. The fear and uncertainty affect not just undocumented immigrants, but also legal residents and even U.S. citizens who live in immigrant communities and worry about being caught up in enforcement actions. Schools are reporting increased absenteeism as parents keep children home out of fear. Hospitals are seeing fewer patients seeking care. Crime victims are refusing to cooperate with police investigations. The unintended consequences of aggressive immigration enforcement ripple through every aspect of society. If you made it this far, you now understand what most people in Florida don't. These aren't hypothetical laws. They're real. They're being enforced, and they're destroying lives right now. Whether you're an immigrant, a landlord, an employer, or just someone who cares about fairness and understanding how our legal system works, you need to stay informed about these developments. Hit that like button if this video opened your eyes to the reality of Florida's immigration enforcement. Subscribe because I'll be breaking down more Florida laws that affect you directly. And these are topics that mainstream media often oversimplifies or ignores entirely. And drop a comment. Do you think Florida's immigration laws go too far, or are they necessary for enforcement? Let's have a real conversation about it. Share this video with anyone who needs to know what's really happening in our state. Knowledge is power, and in Florida right now, it might be the only thing that keeps you safe. Stay sharp. Stay
informed. I'll see you in the next one.